Occasionally lecture at our church. I may have said this before, and I always say good evening, whatever. And I keep saying one day I'm going to say good morning Vietnam. It probably won't work.
Where is Vietnam?
Well, don't you remember it was Bill, some comedian? Good morning Vietnam. Good morning, everyone. As indicated, my daughter Melissa is here, and I've asked her to say a few things. There are lots of current topics led I'm sure, by Ukraine. Melissa said that state Supreme Court justices are not experts on Ukraine, even though I think they are. So she's going to probably avoid that. Talk more about voting and voting legislation and voting regulations.
Maybe.
Or not. Melissa.
Thank you. This feels very loud. Does it feel very loud to everyone or just to me?
Just to you.
Just to me, okay.
We're all deaf.
Okay. So can I see a show of hands? How many of you read the materials that my mom and dad sent out?
Good.
Okay.
Lots of liars here.
That-
Scam.
So I read them yesterday, and based on having read them, I totally changed what I was going to talk about. The first article included in that set of three pieces, it was put together by, it wasn't identified in the materials, but I Googled. It was put together by the Alliance, I've already forgotten, Alliance for Progress campaign, which is a very, very progressive organization that you could tell if you did look at it, had a particular take on why state court judges matter. That was the title of the article. And as the invitation to this morning indicated, I am a state Supreme Court justice in Colorado. And reading that article made me want to talk to you about not so much why state Supreme Court justices matter, although I hope we do, but what state Supreme Court justices do and why you should think about state Supreme Court justices and judges differently than the Alliance for Justice campaign does. Because even though it won't shock you to learn, as Bob's daughter, I am myself quite liberal. My job is not the space where I live out that set of values, and I don't think it should be. I can do whatever I do in the voting booth, and I do, but when I'm doing my job, it's a different thing. And I think it's really important for people to understand that. I think it's really important for faith in our justice system, which has eroded tremendously in the past, basically since I've been alive, but certainly in the past, let's call it decade. I think it's really important for people to understand that as judges, we're doing something different than politics, because I truly believe that that's the case. I was appointed to the Colorado Supreme Court in 2017, right at the end of 2017. And so the first set of oral arguments that I heard was in January of 2018. And one of the cases that we heard, when you start, I got this set of briefs in 8 different cases, like tons of reading. And one of the cases that I read, I started reading the facts, and the facts were an agricultural employer who treated their workers terribly. And the workers didn't get paid the overtime that they had done. And I read it, and as I was reading the facts, I thought, I am clearly ruling for the workers, because my set of values says employers shouldn't treat workers this way, and I'm going to be sure that the workers get what they deserve. In a brief, I don't know if any of you are lawyers, but in a brief to an appellate court, you start with the facts and then you get to the legal argument. So again, reading the facts, it's like vindicate the workers' rights. Then I got to the law, it's like, nope. this out, even though I feel like these workers were treated badly, and even though I think something should be done about it, this legal argument just doesn't do it. It doesn't work. The law is not on their side. That ended up being the first opinion that I was assigned to write for the court. And I felt, even though I felt disappointed for the workers, who is it? Even though I felt disappointed that these workers' rights wouldn't be vindicated by this lawsuit, I felt a sense of great relief that I knew that I was going to be able to do this job of being a judge. I knew that my policy preference, what I wished could happen as a matter of policy, couldn't happen as a matter of legal analysis, and I was able to make that distinction. I was able to recognize that my job was not to do whatever I wanted, but to do what the law permitted me to do as a judge. And I have ever since said, that's the first question you should ask any judge. Give me some examples of times that you have had to rule in ways that you wished the law wasn't that way. You wished the law was different than what it is. Because if you were a legislator, if you were choosing, you would have enacted something different. But since you're not a legislator, you have to do what the legislature said. And if you ever find a judge who can't give you an example of a case like that, that is a frightening judge. Because there is no judge, left wing, right wing, center wing, there is no judge whose policy preferences are always what the law says. There's just no such thing. And I feel like that's a really important thing for people to recognize, that good judges are not vindicating people's rights. That's not the purpose of a judge. We are really trying to apply the law as the legislature has written it. I did some research yesterday about judges in Florida and how judges are selected in Florida. And if the website I was looking at is correct, and it's totally possible it's not, but I'm hoping it's correct, your trial court judges are selected in nonpartisan elections, and your appellate judges are selected very much the same way that I was selected, that judges in Colorado are selected, which is there's a nominating commission to which people apply if they're interested in serving as a judge. And then that nominating commission sends a set of names to the governor, and the governor has to pick from that set of names. I think that's a great system for selecting judges. Because what it does, at least in Colorado, and I didn't look into the details of the Florida system, but in Colorado, our nominating commissions, we have nominating commissions for all judges, but our nominating commission, I'll talk about the appellate system, it has 15 people on it. It has to be 8 non-lawyers and 7 lawyers, and that's because we don't want it to just be a little cabal of lawyers choosing the judges. You don't want just all the inside baseball kind of people. You can't have a majority of any political party. So you have to have, the ideal would be 5 unaffiliated, 5 Democrats and 5 Republicans. But in any event, it can't be a majority of any political party. So that tries to take the politics out of it. This can't be just a political campaign. And in Colorado, and I'm guessing this is true in Florida, although again, I didn't look into the details, you have to have representatives from each of our 7 congressional districts. So you have people from rural parts of the state and people from urban parts of the state, people from all over the state, again, to try to avoid sort of the folks in Denver just picking our judges, because our appellate judges are judges for the whole state. And so we should represent the interests and have an understanding of people all over the state. And that group of people, that 15 people on that nominating commission, they do interviews, and after the interviews, they send names to the governor, and the governor can't say, well, you didn't send me the person I wanted. I had someone in mind, and you didn't send me that person. And so that sort of gets rid of the patronage piece of it. So it really tries to neutralize some of the biggest problems, I think, with what you might see in judicial selection. And because of that, and I think in Florida you have a similar system. I think you as citizens should be able to trust that your judges are not trying to advance a political agenda, that we are trying to apply the law as the legislature has written it. Sometimes that's incredibly frustrating. It may not shock you to know that legislatures don't always do a great job writing laws. And there have been many times I've only been on the court for 4 years, but in the 4 years that I've been on the court, many times where it seems to me that the legislature didn't want to make a decision. They left things vague in the hopes that courts would make their own decision. But my experience has been that we don't feel like we can. Once you come into this role of judge, you really feel like that is not my job. My job is to do what you wrote. So I have written, and I've also voted on many opinions that my colleagues have written that have basically said, it seems confusing that this is what the legislation says, but we have to apply what it says. We hope, we often actually write directly to the legislature, basically, in our opinions. We often write and say, we think you might want to clarify this. This doesn't seem to make a lot of sense. But it's not our job to make it make sense. That's not what a court should be doing. And I think that's really important, and part of why, with all love and respect, I totally disagree with the first article that was included in your packet. No, I think it's an important perspective to recognize that that's how many people do think about judges. Many people think we should celebrate state court judges because they can do progressive things. I think state court judges can do progressive things if the legislature did something progressive. If you had a legislature, say Washington State was one of the articles that was referenced repeatedly in that article. And Washington State's legislature is very progressive, so it's not a surprise that the state court ends up with progressive decisions because they're looking at legislation that is progressive, and that's great. That's what Washington State's voters chose in their legislation, in their legislators. They ended up with that legislation. But I think to suggest that it's the judges doing it rather than the legislature doing it interferes with our confidence in a rule of law and not of men. Interferes in our confidence that there are judges in every state who can be impartial and fair and can look at what the law is and say, this is what we have to work with, and we're going to work with it. So I apologize. I haven't talked about voting. Dad said I should talk for about 15 minutes. I'm really happy to talk about voting and voting legislation, but I may be in a Q&A type situation. But I really just wanted to get that out there, that I think you all, as citizens of our country, should feel the most confident in our state judiciary and our federal judiciary. But I'm at the state level. When you know that what we're doing is really trying to inhabit that judicial role and not inhabit the role of a policymaker. We're really trying to apply the law as the legislature has sent it to us.
I know that there are at least 2 judges here. I don't know how many, but just by show of hands, the former judges. I know Jack and Phoebe. It counts. Does this resonate? Does this make sense as Melissa described it? Jack?
The wife of the judge.
Oh, that's right. Exactly. Tom is a judge. And is it difficult to maintain that I'll call it judicial purity and not lean toward one side or the other? I would assume every judge is appointed by somebody, and they got there in part because of their political ambitions, right? Or political interest, let's say it that way.
So I don't find it, again, I don't find it as difficult as I was worried that I might. And I will say what I have been an outspoken person. It shocks you that as his daughter, that I have been an outspoken person all of my life. People knew when I was appointed that I was a liberal Democrat, and actually there were campaigns against me, like affirmatively campaigns against my appointment by business organizations who thought I was going to be too worker-friendly or plaintiff-friendly. And there were campaigns for me by plaintiffs' attorneys, civil, trial lawyers, sort of. And I have disappointed the people who campaigned for me at times, and I have surprised the people who campaigned against me at times. And I have had moments where I have thought, oh my gosh, I actually, literally this week on Monday, an opinion that I wrote issued, and it went against a man who's a huge Democratic donor, who I know called the governor on my behalf. And I thought, oh, he must be so angry, but the law just wasn't on his side. Like I'm not a politician. That's not my job, and I need to do what the law requires me to do. So but I did have the thought. I recognized, this is like someone's going to be really angry and feel that somehow I was supposed to do this for them because they supported me. And what I have to do is I have to recognize they may feel that way, but I can't. I need to do what I'm supposed to do in my position and not worry about what they think.
Have you not seen or witnessed even in your own court egregious examples of the opposite, where judges allow themselves to be swayed politically? And I'm asking that both of Melissa, but of anybody who's experienced judicial proceedings where that purity of thought is not exactly applied. Do you understand my question?
Yeah. I have not witnessed it. And I think one of the things, so in the States, judges are selected in a lot of different ways. In Colorado, we have, as you do here for your appellate courts, retention elections. So there is an opportunity. You could vote out a state Supreme Court justice, and I could get voted out in Colorado. But it's all on you don't put a D or an R next to your name.
But isn't that extremely rare?
The people
to be retained?
Yes. In Colorado.
Is that true here in Florida too, retention elections?
Yes.
It is. And likewise, very, very seldom does it happen that judges are voted out. It has happened.
So,
Yeah.
I don't know how it works here. In Colorado, we have a performance commission, and the performance commission makes a recommendation, retain or do not retain. And part of the reason we don't have a lot of failure to retain is because a judge is told in July of their election year, the performance commission is going to give you a do not retain recommendation. And that's going to be on the ballot. Like, that's what people are going to see. And those judges tend to decide that retirement is a solid option. But every once in a while you have a judge who says, I'm going to do it anyway, but they tend not to be retained.
More often than not, they retire before they're thrown out.
But I do think, I will say just...
Maybe.
Hold on.
Just a second, we've got a mic coming slowly.
I'm so close.
What about gerrymandering? Have we gotten any of those cases?
So that's actually in the notes that I left back at the hotel, which is probably just as well because I'd be reading them. One of the cases that I was going to talk about is in Colorado this year for the first time, redistricting was done by an independent redistricting commission. It was a constitutional amendment that the voters passed a couple of years ago. And again, this is an example of Melissa the human and Justice Hart the judge. Our redistricting commissions for the federal level, we've got a new district because our population has increased. And our redistricting commissions did the redistricting in a way that was entirely compliant with the Constitution, but that advantaged Republicans pretty significantly. They could have done this, they could have complied with the Constitution, but advantaged Democrats. And again, as a Democrat, when I looked at it, I thought, what? But as a judge, the question was not, is this the map I would prefer? The question was, did it comply with the Constitution? And the answer was yes. So we don't have the same kind of gerrymandering problem because we have an independent commission. So I would have to confront that. But I think it's just another example of, like, it's possible to separate.
Not here.
Well, that's too bad. That should be how it works everywhere, because at some point, whichever side you're on, you're going to be in the minority, and you want people applying the law who aren't on a side, who are impartial decision makers. The idea of judges who aren't impartial decision makers, to me, is really scary.
Go ahead, what, Forrest?
I just say it's scary to us.
You find it scary too?
Yeah, I do. Either way, it's not a party issue, it's just, I don't like it.
Yeah, I mean, the whole concept of the rule of law is the idea that it isn't about which side you're on, that it's going to be applied neutrally.
Doug?
Yes, I'd like to ask a question in a totally different area, but first I want to thank you for your introduction. I am aware that one of Trump's nominee for the U.S. Supreme Court you personally knew, and my understanding is you wrote a very honest, personal letter about that individual. So I thank you for your introductory remarks, and to me your behavior matches your remarks. Now my question. Colorado is ahead of the rest of the country in terms of marijuana laws. And from an employer standpoint, most employers historically, if they have employees operating machinery or something like that, take a drug test, and for someone that fails a drug test, they're automatically scratched from employment. So have there been any cases in Colorado of further defining exactly how you balance the employer's request for safety with respect to the current laws of Colorado?
Yes, and I'm trying to remember the name. Dish Network, right? Was it Dish? Before I joined the court in 2015 or 16, I think, the court said if an employer has a policy that you can't be using substances at work, including marijuana, just in the same way that you can't be drunk at work, even though alcohol is legal, you can't be stoned at work. And so if you have marijuana in your system, it's a permissible employment policy to say, nope. Which I think balances exactly what you said, the concerns about a safe workplace with what is now a constitutional right in Colorado, the right to possess and use. I don't to stay unemployed. The right to possess and use an ounce of marijuana, I believe, is the amount.
Interesting that when Melissa publicly endorsed Gorsuch, the Supreme Court Justice, I was surprised, though I did applaud her doing so. I'm not so sure that you don't regret that today. And I think I'll say it in a different way. Regret having made an endorsement one way or the other as a future judge. You were not a judge at the time, right?
No.
Yeah. You wouldn't endorse anybody today.
I don't think it would be appropriate for me to do that in my role as a judge. I don't regret endorsing then Judge Gorsuch. I deeply, deeply disagree with his opinions on the bench, but we had a president who was going to appoint people who had Justice Gorsuch's views, and I think among people who have those views, just as there is no reasonable argument that Ketanji Brown Jackson is not qualified to be on the Supreme Court. She was a year behind me in law school. She's one of the most brilliant people I've ever known. She's a deeply qualified person who should be on the Supreme Court. I don't think there was a rational argument that Neil Gorsuch was unqualified to be on the Supreme Court. So, I can totally disagree with or almost everything he says, but that's not a qualification. That's a political disagreement. So.
Cool. Jeannie? Not Jenny? Gene?
Given your very admirable attitude about complete impartiality, it seems strange to me that on our own Supreme Court, typically, one can predict the outcome of the different judges' decisions based on their political background. And it's just concerning to me that here we have the Supreme Court and people are apparently not applying the same kind of ethics that you are.
Can I ask, are you talking about the U.S. Supreme Court or the?
Yes,
So I think one of the really unfortunate realities is that our societal views about judges are largely shaped by what we hear and read about the U.S. Supreme Court, because the U.S. Supreme Court is dealing with a completely unique set of legal issues. There is no other court in the country that deals with the set of legal issues that SCOTUS, the Supreme Court, deals with. The bread and butter of my work is truly it's statutory interpretation. It's applying Colorado law. What the cases that we most often read about from SCOTUS are cases about the meaning of a couple of words in a document that was written over 200 years ago. And frankly, I think that it is very, very hard for that not to become ideological, because there is so little content. When you are talking about so little content in the Constitution, there is so much need to add that gloss, that interpretation. And so I do think the Supreme Court, the U.S. Supreme Court, is significantly more ideological than any other court in the country. And I don't know how we get out from under that. I will say, I think it's really important to note that when they're doing the vast majority of their work, which none of us pay attention to, like 80% of the cases that they decide are also statutory interpretation cases where they're unanimous or strange bedfellows. You can't predict ideologically. The cases we can predict ideologically are the ones that have to do with interpreting, again, either no words or almost no words in the Constitution. And I don't know how anyone could do that without imbuing their interpretation with their own perspective on the world. So I don't want to say I'm at peace with, because I'm definitely not at peace with, but I've come to terms with the reality that, the cases we focus on, and that's not all the cases, but the ones we focus on from the U.S. Supreme Court are in fact ideological. Which is why it matters, with elections matter. That's the reality when you look at that small subset of cases that the Supreme Court deals with.
Forrest? This is being recorded for time and all.
Oh, I asked you if it
So
wasn't.
that's why we have mics.
I see. So I shouldn't swear. Okay.
This is a joke. Melissa, the question I have about the current nominee to the Supreme Court, I've heard her speak. She speaks beautifully. And I'm not a lawyer, so I don't know how to interpret her work, but I have read that multiple decisions that she's made were overturned by higher courts. Should that concern people with her nomination?
Absolutely not. So I'm assuming everyone heard the question. One of the things that, and I don't think I understood this until I became a justice, but the volume of work that trial courts do, the number of decisions that they have to make every day is absolutely unmanageable. Like and we have a couple of judges in Colorado, and I'm sure you do here in Florida, who have what we call decision paralysis, where they just sort of stop and they can't make a decision because they want to be sure it's the right decision. But the whole point of our system of having a trial court and then an intermediate appellate court to which everyone can appeal, right? If you lose in a trial court, everyone has a right to appeal to that intermediate court. And the reason for that is because trial court judges making so many decisions are gonna make mistakes. And we would prefer to have them actually make decisions instead of just stopping, recognizing they're gonna make mistakes, and then the appellate courts can fix those. So the fact that a judge, that we often have this, my colleagues and I, when we're talking about decisions, the exact thing will often come up, he's a really good judge, I'm surprised. Like those words will be said, but really good judges will make wrong decisions. And we'd rather have them make the decisions and have those decisions reviewed than perseverate over whether their decision is right. So I don't think it's concerning at all. I don't know a single trial court judge who hasn't had things overturned.
I just want to follow up on that because it would concern me, and maybe you're saying unfairly so, it would concern me if a lower court justice or judge being considered for a higher court position had made relatively more mistakes than someone else. I would think we would go for the person whose lower court decisions were more accurate or better reasoned. Does that make any sense? A lot of reversals would be a signal of
Well, and I guess,
something
and I
to
don't
this.
know what you've read. I don't think it's the case that Judge Jackson has an unusual number of reversals.
I don't know.
I think it's. I've read some stuff about it too, and I think she is not. I mean, again, just speaking from experience, there are some judges in Colorado who, when you see their name on an opinion, you're like, oh, there will have been a mistake made, certainly. But she's not like that. She's not a unusual. Again, I have read some stuff about her, besides also knowing her personally. And so yes, a judge who is outside of the norm in terms of the number of reversals, that would be
That's
very
fine.
concerning.
Yeah.
But even the very best trial court judges just do get reversed sometimes. That's how the system works. That's what we want.
That's why we have appeals.
Yeah. I think, Sue, did you have that?
So,
What is the norm? Where's the money?
The question is, what is the norm?
What is the norm? You're talking about the norm.
Well, I think that,
Percentage?
yeah, I mean, so
What is it?
that's a good, so the question is, what is the norm? What's the percentage of time someone will be overturned?
15, 20, 30?
And I actually don't know the answer to that question. 50% I would find concerning.
15 or 50?
50.
I would say.
I'm just asking.
Yeah, no, that's a good question.
So,
I see. First of all, Melissa, could we clone you?
Oh, that's nice of you.
I know that Supreme Court justices do not have by law the requirement to recuse themselves from cases. However, do you think Justice Thomas should recuse himself from all the cases in which his very, very active far-right wife participates in?
I think the Thomases should have had a conversation when he became a justice in which she agreed that she wasn't going to participate in the activities that she participates in. That's actually what I think should have happened. But yeah. Are there some cases from which he probably should have recused? Let me put it differently. Are there some cases, once she decided I'm gonna do what I do, are there some cases where if I was in his position, I would have recused? Yes. Is it as many as some people think? Probably no. I think some of her activities have really been too engaged in the case, and some not so much. But I mean,
Good question.
my husband is here. My husband and I, he works for the federal government as a lawyer, and when I said I really want to be on the state Supreme Court, we talked about it and said this should be fine because since he works in the federal system, there shouldn't be any situation where there would be a problem. And I just think you need to have those conversations as spouses. And maybe they did, I don't know.
Jim? Jim and Ken, Jim and Don.
Thank you very much for coming and talking about this. And thank you for clarifying the material that your father sent out as well. I was very concerned about the whole decision of the court. And so you answered that question very well. I have a second question, and that is that in electing judges, I probably have never made more mistakes than voting for a judge I didn't know anything about.
Same.
And I'm just curious about your thoughts about how we as voters could be informed better about the background and decisions and pre-elections of judges, either in a recall election, or a re-up election, or a new judge.
So that question makes me embarrassed by the fact that I didn't research whether Florida has performance commissions that do recommendations. Do you know what?
I don't know the answer to that. Does anybody know? Do we have performance commissions? Is that what they're called?
Yeah, so I'll just say in Colorado, when a judge is up for retention, they do an interview with the performance commission. The performance commission watches them in trial or in an appeal. There's a survey of lawyers that have appeared in front of the judge. There's a survey of other judges about the judge. There are several different interviews, and then the performance commission produces a report that says, here's the upside, here's the downside, here's what people say, and on balance, we recommend retention or we recommend that they do not be retained. And what I say to people in Colorado is, I 100% of the time look at that and go with that. If there's a judge that the commission has evaluated and says they're not good, they're not doing their job well, I mean, our system is supposed to then have them not be there anymore. So I hope you have something like that in Florida. You don't,
No, in any state I've ever voted, I've never seen anything like that.
So,
Maybe they do it, and don't have access to it. I don't know.
well, and that's, in Colorado, it's astonishing to me how few people know about it. So you could have something like that here, and it's just not, people don't know about it. And I don't know the answer to how we get that information out there, but I think that's the best way. I don't think,
But I thought you said judges who are deemed not suitable for retention very frequently choose to retire.
yeah,
Rather than face an election where they're turned down.
most do, but we have had judges in Colorado who have gone ahead and stood for retention even though it says do not retain as the
And won
recommendation.
and prevailed.
No, they tend to lose.
Oh, wow.
They tend to get voted out.
John?
On the ballot, there's nothing more than the statement, shall Judge so-and-so be retained? Yes or no?
That's what I remember. You don't see a discussion of the judge's qualifications.
So, and that's the same thing in Colorado, but there's something called the Blue Book, and I don't know if you have something that discusses, like, I don't know if you guys, we have a lot of ballot measures in Colorado, so the Blue Book goes through, like, here are the different ballot measures, and it gets mailed to every home, and and that's where you'll see the performance evaluations of the judges.
I think we do have that for any ballot issues here as well.
I will also say, so I was retained in 2020. And it was weird because it was COVID and my law clerks weren't in my office. And it took me a while to realize that the reason my phone was ringing off the hook, because I don't answer my chamber's phone, because that's what my law clerks are supposed to do, but they weren't there. It was ringing off the hook in October, and I couldn't understand why. And then my colleagues and I were talking, and one of them said, well, it's people calling to ask you about your views in advance of the election because they want to decide whether to go yay or nay. And people were, I ended up then, because I wasn't answering my phone, with dozens of messages, and it was, do you support abortion? What's your view on gun rights? Are you a Democrat or a Republican? And I was very happy that I hadn't answered the phone, because my answer to all of that would have been, I can't speak to those questions, that's not my job. That's not why you should be deciding whether I'm a good judge or not a good judge. So that's why I think these performance commissions who really look at how are you doing as a judge, how are you doing your job, rather than are you a Democrat or Republican, are really important.
How would you change our judicial system at the state level if you were asked to do it? I can't imagine you think it's perfect as is, but it might be, I don't know.
I think in every state I would probably have more judges. I think the volume of cases is so huge that many people feel like it takes too long to get their cases resolved. And I don't think that's because judges aren't working hard. I think, in my experience, judges work very hard, but there's just so much. Yeah, so Phoebe said it should be done by population. I think that's right. I think, unfortunately, it's not population, it's money. It costs money to pay for a judge and the judge's staff. But it's definitely the case, I think, from what I read everywhere, that everyone feels like the system is moving too slowly. The other thing, I'm big, my passion is civil access to justice, making the civil justice system work better for people. It's too expensive. Again, it takes too long. In more than half of civil cases in state courts, litigants don't have lawyers because lawyers are too expensive. And so people are trying to navigate those cases by themselves. And the forms and things that courts use are way too complicated. So if you're on your own trying to represent yourself getting a divorce or have a small claims case or you are facing eviction, you have to try to figure out on your own. The easiest example, does anyone know what forcible entry and detainer is? Anyone? Forcible entry and detainer? So if you got something saying you're facing forcible entry and detainer, it's an eviction. But courts don't call it that. They call it forcible entry and detainer. Why? Why? Does that help anyone? No, nobody knows what we're talking about. So one of the things I'm very passionate about and I'm working on in Colorado is making courts work in plain language in ways that people can understand. Because we're supposed to be serving you. And we're not. Or not always. So that's the other thing I would change.
One of the arguments I've heard for expanding the size of the Supreme Court is not so much to have just more justices at that level, but to have, say, a pool of 16 or 18 from which 9 have to decide on various issues, but that would allow more, fewer cases per justice, and thus a better system. Now, as soon as you say Supreme Court, that's stacking the court. At a lower level, does that make sense? Just have more judges?
So I think we need more trial court judges, for sure. I think in Colorado we need more intermediate court of appeals judges. We don't need more justices. Our job is not that hard. And the U.S. Supreme Court, good Lord, they do almost nothing. I mean, honestly, I clerked at the U.S. Supreme Court in 1996 for Justice John Paul Stevens. And that year, I think the court decided around 90 cases. Now it's deciding around 70, 72 cases. I think it was below 70 last year.
In contrast, how many cases does your court decide?
Let's see, last year, I think it was around 130. Which again is still
not very bad.
Compare that. So our appellate, because we get to, like the U.S. Supreme Court, we have what's called certiorari jurisdiction, which means we get to choose what we hear. So if cases come to us that we just think aren't worth our time because it's not important to decide them, we just say no. Our Court of Appeals doesn't get to say no. Everybody has a right to appeal to them. Each of the judges on our Court of Appeals writes an opinion every single week.
Wow.
And then and they're on 3-judge panels, so they each write an opinion every single week, and they're voting on 2 others every single week. So their volume of work is just extraordinary. And again, they make mistakes, just like trial courts make mistakes. They make mistakes. We get opinions from the Court of Appeals sometimes that are just wrong, and they just didn't apply the law. And you think, at first, when I first started, I just thought, oh my gosh, this is shocking. And now that I've seen it, I just think it's the volume. They just have to decide so much, so quickly, that there are gonna be mistakes, and that's why we're there, because sometimes we can step in and say, this mistake is big enough that we need to fix this mistake. And because we have a lesser volume, we can take time, we can think about it. I'm sure we still also make mistakes, but I think because of the time, I think, knock wood, we make fewer mistakes.
And your cases, at least at the state level, if it doesn't involve some federal issue, are not subject to appeal. Yours is the final decision.
Yes, on questions of Colorado law, ours is the final appeal. If it involves a federal issue, it could go to the U.S. Supreme Court.
Ken?
Well, Melissa, thank you very much for being here. Frankly, I had hoped to see you in your judge's robe. Do you rule on criminal cases?
Yeah, about 65% of our cases are criminal. And that has to do with the structure of litigation. Criminal lawyers, so criminal cases, the vast majority of the defendants are represented by public defenders who they don't have to pay for. And in Colorado, our public defenders feel that their obligation to represent goes through petitioning to the Supreme Court. So we get hundreds of petitions from criminal cases. In civil cases, you pretty much have to pay for your lawyer. So the civil cases that we get tend to be very big dollar cases because it's worth it to the people who are involved to pay their lawyer. But it's just a much smaller number because it's just so expensive to go through that process.
Excuse me, he's not in his normal seat, but we have a question.
When a case comes before you, what's your thought process as you approach this?
I don't know if this is directly answering the thought process question, but I'll just say sort of when I have a case, what I do with each of the cases. So I'm hopeful that you all will appreciate this because we're of an older generation than my children. I find it really, really hard to read and retain what I read on a screen. I really need paper to remember what I'm reading. So I print out all the briefs, and then I'll do a very quick read-through of the briefs, just really quick. I want to get an impression, okay, what is this issue about? What are the kind of contours of the arguments? Are there arguments that I can just say, okay, that's nonsense? Because there, unfortunately, frequently are sort of add-on arguments that are just nonsense. And then I try to do that when things are going the way I want them to go. I'll do that, and then I'll sort of let it all sit for a week. And then I'll go back and read much more carefully, taking notes. But I sort of I'll approach it at that point knowing that I have a sense of what the issues are, so I'm not completely new to them, or they're not completely new to me. Again, because of my fetish for paper, I have a set of Colorado statutes in my office, the books. And whenever I'm dealing with a statutory interpretation case, I will pull the book out and I like to see, so you've got this one sentence provision, where does it sit within the entire statute? Sort of what's the structure of the statute? I think you get a better sense of what the legislature is trying to do if you can put it in context. So that's a lot of how my mind works, is I want to understand the context of the question that I'm being asked. For me especially, I never did any criminal law before joining the court. So for me especially, really understanding, okay, we've got these criminal statutes with different kinds of penalties. How does that work? I feel like I'm always, every case I have is a new opportunity to educate myself more about that question. Did that answer the question? Ish?
That's fine.
Thank you.
Okay, we have another question.
Don, later, right here. And you've got another question back there, Sal?
Here and here, got two more coming.
Okay.
On the federal level, would it be accurate to say that society has outgrown the Constitution?
That's a great question. Constitution. I think that
Could you repeat that?
the question is, on the federal level, has society outgrown the Constitution?
So but does that, in effect, give the courts an opportunity to make law?
And therefore courts can make law because I mean, I do think we are seeing in a variety of different ways, and again, whichever side of the political spectrum you're on, ways in which this document that was written 250 years ago doesn't quite work with the way the world looks now, that the founders, as brilliant as they were, and as just extraordinary men as they were, just couldn't have imagined the internet. That just didn't, the world is really, really different. So I think the answer is probably yes for that reason. What we do about it, I don't know. I think there's obviously a great deal of discontent with judges making law. The idea of a constitutional convention is a little terrifying because who knows what we'd come up with. But I think our country is struggling with that problem a lot. And it's interesting, and this comes back to the question that was asked over here about whether we see criminal cases. We see such interesting cases about technology in the context of criminal cases. For example, we had a case last year. If the police, without a warrant, put a pole camera up on the pole that's looking into your backyard and leave it there for 9 months, have they violated the Fourth Amendment? Yes or no? What would Thomas Jefferson say? Yes or no? We said they have violated the Fourth Amendment. We said they would need to get a warrant to be looking into your backyard for 9 months. In doing so, there's prior Supreme Court case law that says anything that could be seen by someone, say, flying over your house, you don't have the right to privacy in. So in theory, a pole camera looking into your backyard is no harm, no foul. But we said the idea that it could be there for 9 months, every one of us, I think, would feel violated by that. The idea that you could just be looking into our backyard for 9 months. But that kind of question, is obviously so different than any kind of question the framers could have been thinking about when they wrote the Fourth Amendment. So it's hard.
So,
Given the rise of extremism that's occurring in our country, do you feel that judges, whether at the Supreme Court level or the appellate level, especially in some circuits, are receiving the necessary personal protection that may be intimidating?
That's a hard and really good question. I know that federal judges are actually given the resources to be able to wipe their private information from the internet, so like their addresses home addresses are generally not available, and they have their technology resources available to them to try to protect some privacy. We're not given that, which is a little concerning. And some of our trial court judges in Colorado have actually expressed a desire to find a way to fund that, because it's really the trial court judges that get the most putting SCOTUS to decide. It's the trial court judges who are dealing with criminal cases, who are dealing with whether it's angry criminal defendants or their cohort, or angry victims, they get a lot of threats. The other thing, and I don't know if this is happening here, but I bet it is, these so-called, just went out of my head. The First Amendment, there's a word that went out of my head, but these people who come and film everything that you're doing. So this is happening in our courts a lot, that Eric Brandt, I'm looking at my husband, people who come and film and sort of try to make trouble and then say, it's my First Amendment right to be here making trouble, essentially, and recording your response and putting it up on YouTube and getting likes and making money by exercising my First Amendment right. Judges feel very threatened now. So do I think there should be more protection? I'm resistant to a world where we have to have more protection, but I think judges feel fearful because of what lies behind your question, because there is a sense of threat.
Another question here.
Hi, thank you for coming. Given that the Constitution was written 200 plus years ago, and we're a very different world now, what about 18-year term limits for SCOTUS on a rotating basis? Life terms to me just seem excessive across the board.
I think 18-year, so in order to have 18-year term limits, the Constitution would have to be amended, but sort of putting together something that Dad said with something that you said, there are organizations in Washington that are advocating, you have a lifetime tenure on the Supreme Court, but that doesn't necessarily mean you have to be actively hearing cases. So could you have a Supreme Court could you say right now, the 9 of you who are there, you've got 18 years or whatever many years, but then you're going to take senior status. You're still on the court, you're still getting paid, that would be consistent with the Constitution, and we're going to replace you. I think it's not partisan. I'm not supposed to say partisan things too much, but I don't think it's partisan. I think that's a really good idea. I do think, and I'll say Justice Stevens, who, as I mentioned, I clerked for, I think is still the longest serving justice, and I love that he served for a long time because I love him. But I do think his 30-some plus years was too long. That is too long for one person to be in that place, and it makes sense to have some movement.
Well,
Melissa, thank you so much for your time this morning. My question is, most of your adult life has been dedicated to service and to the law, and also obviously the teaching of the professor and everything. When in your life did you know that you wanted to pursue the law and be involved in the law? And was there any particular experience early in life that impacted you the most in terms of that decision?
I think it was when my really mean brother, Will, this is my brother. So I did not want to be a lawyer when I was a kid, at all. I really had no interest in being a lawyer when I was a kid, and certainly I really wanted to be a journalist when I was in college. But then my senior year of college, and my daughter is also over there, I'm not telling the whole story. My senior year of college, I realized that my mind engages with law in a way that's different from how it engages with anything else, that the reasoning of the law really works for me. So it was my senior year of college that I decided I wanted to go into law. And the number, by the way, during law school, the number of different things that I thought I wanted to do with the law is like 6 or 7. I want to be a prosecutor. I want to do EU law, so that I lived in Greece for a year between college and law school. I want to move back to Greece, so I'll do EU law. And I did not know that I wanted to be a judge until about 12 years ago. So.
Neil?
I'm curious to know if you think the law schools are able to keep up with the rapid change in technology, because that's where all the lawyers come from, school.
I think law schools are deeply flawed and need to be completely restructured. So, and I say this, Will, more clear. My brother Will referenced that I was a professor. I taught at CU Law School for 18 years, University of Colorado Law School for 18 years before being appointed to the court, and I still teach as an adjunct professor at CU in the fall and now at University of Denver in the spring. So I'm still teaching one course all the time. I love teaching law. I think law students are amazing. But I think law schools, your question, Neil, is about technology. I think law schools have not kept up with teaching technology. I also think they just don't teach people how to be lawyers. I think people come out of law school and still don't really know how to practice law. And they do teach you how to take a test. But most of life is not a 3-hour timed test. And I think law schools, and by the way, when I graduated from law school, 37 years ago. Is that right? 27 years ago. I came out with a little bit of debt, but now the average debt that people come out of law school with is $115,000. That's the average. And many people come out of law school with over $200,000 of debt. And as it turns out, lawyers, actually the vast majority of lawyers don't make six-figure salaries. People think lawyers somehow make a big ton of money. Some of them do, but most are, better than working at McDonald's, but it's not, paying off $200,000 in debt is not an easy thing to do. So I think law schools charge too much for what they offer and need to think about what they offer and whether they should be offering different things. And I think technology is part of it. I think just a more practice-focused, fewer 3-hour times tests that don't test the skills you need in life. But it's really hard to change big institutions, and most people who go into law are very risk adverse, and so they don't want to change. Change happens extremely slowly in the law, and that includes law schools. So I'm not sure what will happen, but I do think it needs to change.
We got 2 more questions here. 3, Bill.
Just a quick, in terms of law students, I have both an uncle and a cousin who went to law school years ago, most of them, but never practiced law. Is that still an element of people going to law school?
Definitely. And some people go to law school never intending to practice law. There are lots of things that a law degree can be useful for that don't involve practicing law. Some people go to law school and find that they can't find a job practicing law. And that's, again, when I think about the debt, that just breaks my heart.
Ken?
Melissa, I think it was President Truman who complained about the 80th Do Nothing Congress. This is kind of playful, but if there were less laws, would that help the courts?
That's a good question. What I would say is, what's concerning to me, and I'm going through something, I won't go into the details of it in Colorado, but we're going through something right now where there's a piece of legislation that would have impacted the court system that hasn't been introduced yet. We're aware of it, we've read it, it hasn't been introduced yet, and of course this is a weird thing, right? Because we try not to get involved in legislation when it's going through the process, because we might have to interpret it someday. So it's kind of okay, we don't want to give you advice about how to write it because we're going to have to interpret it someday. But one of the key sponsors of this legislation, I'm not joking, I wish I were, has not read it. And so when we say to this legislator, it says this and that's a problem, he says, well, that's not what I've been told that it says. So I think there should be fewer laws like that. I think that it would be better, I think it's the responsibility of legislators to read the laws that they are going to pass. And if that happened consistently, we would be better off.
Yeah.
I'm under the impression that the ratio of lawyers to population in Japan is a number 1/3 of the number in the United States. Obviously, ethnicity makes a difference. There is a vast difference in the ethnicity in the United States. Do you have a comment as to the quality of law in Japan versus the United States?
So, I don't, because I don't know about the quality of law in Japan, so I can't do a comparison. And the inclusion of ethnicity in the question, I don't want to comment on that, because I want to stay back from that, but I will say, I think there are too many law schools in the United States, and I think there are too many lawyers. And again, this comes back to sort of combining a number of questions. There are too many law schools in the United States that graduate students who never pass the bar. So even if they wanted to practice law, they just don't pass the bar. And I think if you have a law school with a bar pass rate of trying to remember, I think the lowest that I saw recently was 27%. If 27% of a law school class is passing the bar, that law school is affirmatively disserving people. It's stealing their money. And I think we should be looking at whether that's possible to change.
Neil has one more question. I'm going to make a comment, wait for Neil. I saw in the paper today an article about two oil men. One was 84, the other 82. And the two of them are doing more drilling for wells than any other companies. And it goes back to an earlier question about when should judges retire? Should there be an age out date? I would have thought those two oil men would have aged out of making new drilling decisions a decade ago at least. And it's interesting that they, not younger men and younger women, are making those kinds of decisions. And particularly at the time when they're making a pot full of money drilling and producing oil.
Well, just if I can say about retirement age or age, in Florida, your judges have to retire at 75. In Colorado, it's 72. And many states, I don't know if it's all states, but I would say most states have some kind of retirement age, which now that being 72 is super young, it feels like, why would you have a retirement at 72? And yet people have asked, well, do you think we should change the retirement age? And I continue to feel like moving new people into these positions is good. And so,
I think so too.
and 72 is young, so you can go do something else. We have a number of former Colorado Supreme Court justices who are practicing in law firms or working as arbitrators. That's a very common thing for retired judges to do. So you can both have movement and cycling new people through and still have people having interesting, productive careers. It's not either or.
Neil?
I don't know what to say about your last comment, because I'm 90 and I'm still working. But that's not my question. When you apply to law school, I'm assuming that you can get the information as to the number or percentage of graduates that pass the bar as an indication of the quality of the law being taught at that school.
Yes, definitely law schools make available to applicants the bar pass rate. It's actually a big part of the U.S. News and World Report rankings, which is so much of how people choose schools. So.
Bill first, and then we'll go back to...
I'm here, why not do it here?
After this job, I'm going to work for an auction house.
You changed sides. I know, because he was
Don't fight over it. Just one of you.
Go, Kat, go.
I just want to thank you so much for your honest opinion, because some of us have grown so skeptical of the Supreme Court of the United States because of the appointments that have gone on. And I think a lot of it is the media exposure, the media always saying, well, this is the way it's going to go. But I thank you for your opinion that I think 30 years and more is much too long for the Supreme Court. But I don't know, do you think 18 years is something, or do they need more experience than 18 years on like that?
So I actually think 18 years is a really good number. I think so I'll say, so now I'm now 4 years in, and I feel like I really understand my job now. For the first 2 years, I felt every day like I was treading water, and I feel now like I really understand what I'm doing. I have, again, coming back to the criminal law thing, I've developed I'm sure there are still new things I will learn. I hope there are new things I will learn. It would be sad not to anymore. But I feel like I have a pretty good sense of the body of law that I'm working with and of prior precedent, and it's kind of making sense to me. So I think to say, let's say it takes 4 or 5 years to get really comfortable, to say then you've got 13 more years to really do it well, I think that's a pretty good number. And I think it gives, again, it creates opportunities for new people to come in.
Last question with Bill, then we've used up our time.
All right, thank you very much. You mentioned in response to one question that were perhaps too many lawyers in the United States. Yet you also mentioned in an earlier comment that we have a terrible access to justice problem. How does reducing the supply of lawyers help that, number one? And number two, what are your thoughts on alternative to authorization to practice law? For example, mandatory pro bono. Several are out there, but that's the one that comes to mind. Mandatory pro bono, increased federal funding for legal aid, and perhaps compulsory service in the legal aid system as a prerequisite to practice. And finally, the Washington State experiment about allowing paralegals to become certified to represent clients. And I'll stop there.
Good question.
All right, I've given hour-long talks just about that question, just so you know. I will not speak for an hour now. First, I think reducing the number of lawyers, the market for lawyers, I think, is broken. The way I try to analogize it is we've produced a lot of limousines, and if you want a limousine, you can definitely get a limousine lawyer if you can pay for that. There are no Corollas. It is not possible for people who can't afford a limousine to hire a lawyer. And that's why there are so many unrepresented people, because there are no lawyers who are trying to serve the market for Corollas. If we could train lawyers differently, if we could go, this is one of the things I would do differently in law school, is like one of the things that amazes me is in law school, nobody ever, among lawyers that I know, nobody ever sits down and thinks, how much do I need to earn to have the living that I want? And then I'm going to set my billing rates at that level that will let me do that. Instead, they say, how much is this lawyer charging? I'll charge the amount that this lawyer is charging. So you end up with a market that says, I'll charge as much as I can find someone to pay. But it means there's this huge underserved community, like the vast majority of people who can't afford to pay $400 an hour for a lawyer, but could afford to pay $100 an hour for a lawyer, and you could make a living that way. So some of it is we need to totally readjust the market for lawyers, which means readjusting lawyers' thinking, which is hard. And so I don't think reducing the number of lawyers will actually have a negative impact on access to justice, because right now the number of lawyers we have still aren't serving the majority of people. Mandatory pro bono. I used to be in favor of mandatory pro bono. I have moved away from that for two reasons. I think when people are forced to do something, a lot of them don't do it well. And I'd rather have people doing pro bono who want to be doing it than people who are forced to be doing it. You mentioned increasing federal funding for legal aid. A lot of the problems that poor people and even middle-income people are facing are kind of people law problems, right? Eviction, debt collection, public benefits questions, divorce, family law is the most underserved area. Those are areas that you really need to build up a skill set in doing, and so I'd rather have more funding for legal aid lawyers who actually know what they're doing than to say to someone who's a corporate lawyer doing business deals, can you please go handle this domestic relations matter? So when I think about sort of how do we solve these problems, I think about where do you get the most bang for your buck, and mandatory pro bono I have come to think is probably not the most bang for your buck. And then what the licensing of paralegals. So for those of you who don't know, Washington State was the first to try an experiment with having sort of a nurse practitioner equivalent for legal services. So a licensed paraprofessional, not a lawyer. You don't have to go through 3 years of legal education to do it. You would have a lesser cost education. They came up with a name that I think says it all. Limited licensed legal technicians. I think starting with limited was just like and they made the education requirements large enough that it was actually still a barrier to entry. So it just didn't go anywhere. I will say in Colorado right now, at my urging, we are about to consider a proposal for licensing paralegals. But we would, instead of creating this whole separate education track and they also required, before you could get your license as a limited licensed legal technician, you had to do 3,000 hours of work before you got your license. So again, like, it just didn't work, but it was designed not to work. So we're using existing paralegal programs at community colleges. Those will satisfy the education requirements. We are still having a work requirement, but I think I want to say it's 1,000 hours, which is a significantly supervised work as a licensed paralegal. I do think I'm hopeful that designed correctly, that could be a solution to providing lower cost legal advice for folks. So,
Great question. Thank you.
thank you.
Thank you all.